to attend this year, but we're happy to be able to provide this webinar and get you some of the essential information. Before we get started, for those of you who don't know my background, I'm a former federal employee myself. I was a federal attorney for several years doing employment-related law stuff, and then I worked many years defending federal managers, federal officials at my old law firm, Shaw, Bransford, and Roth. As I stated, this is going to be a brief 15 or 20-minute webinar. These webinars usually take about an hour and a half, so I'm going to run through a lot of material very quickly, and will certainly be available to ARMA's leadership and its membership later throughout the year to answer any specific questions you may have. Let's start off with what I think is the most important concept to appreciate is the reimbursement. Congress has required all federal agencies to reimburse managers, supervisors, and law enforcement officers up to 1/2 of the cost of the annual premium for professional liability insurance. I've started the presentation with this because it's important for you all to appreciate that this official support for professional liability insurance from Congress demonstrates Congress's understanding that there are risks associated with your federal employment that cannot be completely cured with legislation. They understand that you need this protection, and they want to share the burden of the cost with you. There are essentially three main areas of what we call liability exposure for federal employees: civil lawsuits, administrative or disciplinary type matters, and criminal investigations. As many of you are aware, with your increased caseloads, without additional staff, that leads to an environment of increased allegations, public scrutiny, motivated criticisms against SSA and SSA managers, accountability demands, not to mention the very active bargaining unit employees that you have who are making, allegations constantly against managers, who are simply trying to get a day's pay for a day's work out of their employees. All of these allegations lead to potential vulnerability to investigations, administrative investigations, and even civil-type lawsuits or even criminal investigations. So this is why the policy was established to cover these three basic exposure areas: civil lawsuits, administrative, and criminal. It also provides, I'll talk about in a second, indemnity protection for that civil type of lawsuit. The policy, I should also mention, provides for 2 pre-complaint, free legal consultations a year. So this is something that's not necessarily has risen to the level of a formal complaint, but maybe you feel you need some legal advice on. We're here to assist you doing that throughout the year. Other policy features just want to mention here in the beginning is that there are no deductibles, and when you retire, you automatically get 36 months of free coverage. We call it the 36-month tail for any civil claims that could follow you into retirement. You don't have to purchase the insurance into retirement. You're automatically covered. We're going to start with civil suits, civil lawsuits. The professional liability insurance provides you with your own personal attorney to defend if you get sued in your personal capacity. And it also indemnifies you up to $1 million or $2 million for a judgment of damages, depending upon the policy you choose. These civil lawsuits are often referred to as Bivens actions, constitutional torts, personal capacity or individual capacity lawsuits. And they invoke some very complicated, legal principles. This is not law school. I'm not going to employ the Socratic method here. But just for purposes of today's discussion, all you need to take away as an understanding is that if you are sued in your personal capacity, you can actually be denied DOJ representation, and you can be held personally liable whether or not DOJ represents you. So even if they do represent you and they lose, it's still a lawsuit against you. You don't have absolute immunity for these personal capacity lawsuits like you do for lawsuits under the Federal Tort Claims Act. So the Fed's policy will appoint an attorney to defend in these personal capacity lawsuits when DOJ exercises its discretion not to defend you in the lawsuit. When does that happen? That most often happens if, let's say, you're being investigated by the IG for some sort of wrongdoing for the very same reason that you are being sued. You can see that DOJ is not going to be on both sides of that. Another distinctive policy feature here with the civil lawsuits is if DOJ is on the fence as to whether it's in the interest of the United States to provide you representation, we will appoint what's called coverage counsel to go ahead and try to convince DOJ that they ought to be representing you, that it is, in fact, in the interest of the United States to represent you. Here are just some examples of civil lawsuits that have faced managers over the years. That first one there, the federal district court judge allowed the manager to be sued personally for firing an employee during his probationary period. That case was actually recently reversed by the D.C. Circuit, but that involved an agency that basically had unfettered discretion to do what it did. Congress had determined that this particular agency, Library of Congress, is which one it was, that this particular employee had no rights to file that type of lawsuits. That's a little bit different than somebody in your agency. So that's all I really want to say, about civil. And just to recap with civil is you just need to be able to take away that you can be sued, you can be denied rep, and you can be held liable for a judgment. The policy protects you in these three ways: legal defense, coverage counsel, and it pays damages. The final point I want to make here is, before we leave civil, is I want to be clear that civil lawsuits against you for doing your job are rare, okay? And it is rare for DOJ to decline to represent you, with actual liability being even rarer. I would say probably less than 5% of the cases end up in that sort of arena where you're going to need the liability insurance to protect you. Nevertheless, it can happen, and for my money, no matter what the percentages are, why would you risk it for $130 a year, which is all the insurance costs you after you get reimbursed. Moreover, the real exposure and the real value of the policy is for the other protections and provisions that we're gonna talk about next. So, the buck for you all is the coverage for administrative matter. So the Fed's policy will pay for legal defense up to $200,000, which will get you from cradle to grave for any administrative matter that could result in a personnel action against you. So what does this mean? This is any administrative investigation, whether it is an OIG, Office of Inspector General, Office of Special Counsel, Congressional, HR-directed, EEO, any internal management investigation. The Fed's policy will provide an attorney throughout the investigation to assist you in responding, and in the unfortunate event that there is a disciplinary action imposed against you, the Fed's policy will provide an attorney to defend, both at the agency level and the Merit Systems Protection Board, if necessary. One of the things I want to emphasize here is that we're really entering a new climate these days, where I see agencies will investigate anything, especially if it is from a bargaining unit employee. I mentioned that earlier. In the criminal arena, there's a famous analogy we give. We call the ham sandwich analogy, where you would say the grand jury, grand jury has to indict somebody before a criminal charge can be lodged, which is something that's very easy to do. We would always say, a grand jury would indict a ham sandwich. Well, we're seeing that, in the administrative arena, where agencies will now investigate a ham sandwich. And when they do, you will be happy that you have a Fed's policy in place to help you respond. These are just some of the actual allegations and complaints that we have seen over the years made against Social Security managers. Just give me a second to review those. This is just a slide that highlights what I sort of mentioned in the beginning of my presentation, is that your major challenge these days is that you've got this rising workload, you have less office staff to get the work done, and that type of environment, usually, adds to where one's actions or inactions, though intentional or well-intended, even by the best, civil servant employees, can often lead to public scrutiny, politically motivated criticisms, accountability demands, the bargaining unit employees, the fact that you have a very, very active union. That's not to say the union's role in this process, in the federal labor management relation process, is not important, because it is important, that employees have that representation. It's just that we're seeing an environment where agencies are pandering to it and investigating it, empowering any complaints that they make, because they just feel that it's easier to do that than to ignore it, I guess. It's also important, I guess, that they do investigate and have an independent party clear the individual so they can respond to any potential future litigation complaints which may happen, but it's just important to have your own attorney to assist you through the process, which is what the Fed's liability insurance does. This is just a slide that emphasizes, this is in addition to what I just said about why agencies need to investigate, is allegations of wrongdoing against Social Security managers. If you do something wrong in your job, if you make a mistake, if there's intentional violations or things like that, it has the potential for significant monetary losses to programs, in individuals' payments, and that has corresponding negative impact. So as a result, the agency is really going to feel it's required to determine the validity of any and all allegations, if for nothing else, for transparency's sake. I want to talk briefly about these special kind of investigations because they really need to be taken very seriously. Not that the HR-related, the management-directed type of investigation should not be taken seriously. It's just that these three types of investigations take on a different level, and it's very important for you to have legal advice if you're wading in these waters at all. I can't tell you how many times I've heard, somebody who is a subject of an OIG investigation, tell me I didn't do anything wrong, and if I did, I could surely explain. If I show up with a lawyer, they'll think I'm guilty, okay? The IG, which investigates fraud, waste, and abuse and employee misconduct, they like making cases against federal officials. That's not to say their role in government is not very important. It's just that, again, I've seen a trend in them wanting to make cases at all costs and investigating matters that are above and beyond the original allegations. And if you've ever, been the subject of this type of investigation, you know that when the weight of the federal government is upon you and there's a magnifying glass, that microscope over you, none of us are perfect. And it's very important to have somebody on your side that is looking out for your interests and could attend the investigative interview with you. So it's important to be properly prepared for any Inspector General interview. And it's also important for you to understand your rights. IGs are criminal investigators, okay? So what that means is not every request for an interview is mandatory. You know, it could be voluntary. And submitting to a voluntary interview is essentially a waiver of your Fifth Amendment rights, which is something you should never do without talking to an attorney first. And, you know, IGs tend to blend the requirements here. They'll say you're required to cooperate because you're a federal employee, which you are. But because you're a federal employee, you don't surrender all your constitutional rights. So there's a process by which they can compel your testimony, and that gives you what we call use immunity, which is how you want the testimony to be taken in any potential OIG investigation to avoid any potential criminal exposure. Again, very typical legal concepts, and it's very important to have a lawyer on your side to interpret those and advise you accordingly. Let me just step back here. I forgot to mention the Office of Special Counsel Investigations. We used to have a different slide for this. We're trying to consolidate. Again, like the OIGs, they should be taken very seriously. They can lead to serious disciplinary action. The Office of Special Counsel is an independent federal quasi-prosecutorial agency, protects the merit principles. They focus a lot on whistleblower reprisal, other prohibited personnel practices, such as pre-selection, you know, just generally violating the merit principles. OSC will allow you to have your own lawyer to defend you throughout the investigative and interview process. So it's important for you to be able to avail yourself to that, because if they determined, you know, a mistake has been made, you know, a prohibited personnel practice has occurred, they have the authority to direct the agency to take disciplinary action against you. And if the agency doesn't, they can take it unilaterally themselves to the Merit Systems Protection Board. Finally, congressional inquiries are another type of investigation that you could be subjected to, believe it or not. And sometimes it is the career employee that becomes the target of congressional oversight, or like I like to say, is served up by the politicals. So it's important to have your own legal representation, to be properly prepared for any of these types of investigations or hearings, so when the music stops, you're not the one without a chair. The final type of investigation I want to mention are EEO complaints. You know, I'm often asked, why do I need my own representation for an EEO complaint? Isn't this a case against the agency? Isn't the agency lawyers required to defend against these EEO complaints? Well, that's true. It is a case against the agency, not you personally. You cannot be held personally liable. And yes, the agency lawyers are required to defend the case. And while your interests and the agency's lawyers' interests are often aligned, what you need to appreciate is that their client is the agency. And that means that their duty of loyalty is to the agency, not you individually. So it could be a situation where they are advancing an interest that's adverse to yours, and it's important for you to at least consult with the lawyer during what we call the investigation phase, where you're required to establish for the record what is the legitimate non-discriminatory reason for doing whatever it is you did in this case or did not do, because that's what the agency lawyers are going to use to defend the case. And if for nothing else, you know, I find that when we cover managers for these EEO complaints, we are the first one that explains their role in the process, or even explains the process to them. So that's important to relieve some of that uncertainty and at least get an appreciation for how these EEO complaints will trickle through the system. And you're just not going to get through a career anymore and not have somebody file some sort of complaint against you in these capacities. And I just think it's important for you to at least have the ability to consult with a lawyer and not have it cost you an arm and a leg. Here are some examples of covered administrative actions involving federal managers. I'll pause here and just give you a chance to take a look at those. Here are some more examples of some actual cases involving Social Security managers because of privileged and confidential communications information. We can't disclose the actual facts. So some of this has been obviously changed to protect the innocent, we like to say. But I think they give you a real good flavor for what's going on in your work environment. And most of you know this. You've seen stuff like this happen to you or happen to a colleague. Here is a message that your national leadership, that NISMA national leadership put out last year. And the reason they put out this information and we assisted them, in a very concerted campaign to educate your membership on what professional liability insurance actually provided, is that these were actual members that were subjected to these personnel circumstances, and they didn't have liability insurance, and they were reaching out to their leadership, their NISMA leadership, asking them for help, and they're not set up to be a legal defense. You're an advocacy organization, you don't have lawyers, it's not a legal defense type organization. So we got together and we developed this concerted effort over about a year and a half now to really reach out and be very aggressive in communicating what it is liability insurance actually covers, and it would have provided a lawyer for each and every one of these instances. The agency, they had their own lawyers to rely on, and these management employees had to defend themselves. So if you had the insurance, it would help you defend against any allegations. It would prepare you for the agency administrative investigative process, which is very, very key. Attend the investigative interview with you if we are permitted in. So it's really discretionary on the part of the investigator, but more importantly, it's getting you properly prepared is really the key, so that we can get in there and put our best foot forward. Finally, you want to talk about criminal investigations. I know nobody came to work today to violate criminal law, but you need to appreciate that there is very little you can do wrong in the federal government and not have it also technically be a violation of Title 18. That's the criminal code. Some of the most common criminal investigations involving federal managers involve misuse of position or authority, conflict of interest statutes where intent is not a prerequisite to prove the crime, misappropriation of federal funds, release of Privacy Act, tax or other statutorily protected information. This is where we most often have seen allegations made by IGs against federal officials. The bottom line is that if you're notified you are the subject of a criminal investigation, it is absolutely imperative and important for you to talk to or retain a criminal defense attorney before you talk to anyone. Okay, it's very important, that you just don't walk in there, blindly without understanding your rights. So here's just a recap of what insurance provides. And I would, just mention here with lawyer hourly rates, ranging anywhere from $300 to $400, even $500 an hour for experienced lawyers. Individuals who are forced to retain their own private counsel can quickly find themselves paying a lot of money, even if the allegations are ultimately disproved. There's really not a process for you to go back and get those fees reimbursed, during the agency administrative process. When I was an attorney in private practice, I can't tell you how many times I saw people, having to mortgage, get second mortgages on their home, depleting their savings, their TSP, when they, if they just would have spent $130 a month, they would have been fully covered, and that is significantly less than just 1 hour with an attorney. Again, we don't have to break the piggy bank. It's for the $1 million policy. It's $270, and the agency reimburses you, so it's $135 after the reimbursement. And if you are a NISMA member, you're eligible for the $10 discount. The discount code, there's a variety of them. It's NISMA, or you can use SSA. I think are the two that are active now. I should also mention here that effective September 1, there's going to be an underwriting price increase that's been mandated across the board of just $20, but still, every dollar counts. So if you haven't gotten your insurance yet, you want to make sure you get it in place before September 1. And finally, I can't emphasize this point enough. The insurance needs to be in place prior to the allegation or claim. Okay, you can't get in a car accident on Monday, buy your insurance on Wednesday. I can't tell you how many people who have called the office after something has happened. It takes less than a few minutes to get enrolled. Payroll deduction is available. You can do it quickly online, print your certificate of insurance right there. You can download, the form, a one-page form from our website, mail or fax that in, or if you don't like to deal with those things, you can just give us a call. We got people on staff here to take your calls and take your enrollments over the phone. And certainly if you have additional questions, we welcome you to give us a call or specifically send us an email to feds, F-E-D-S, at fedsprotection.com. And so that concludes my short presentation here today. And I hope you all have a good rest of your regional meeting. And thank you.